I was just talking to Justice Gableman on the way up here. He's a dear friend of mine. You know, the Supreme Court's been a tough place to work for a little while now. And if you're going to re-up for another 10 years, you have to want to continue to do that kind of work for another 10 years. And, you know, he decided that he did what he came to do. So he wasn't intimidated by a campaign in the least. In fact, that's probably the one thing he would have enjoyed the most. But he felt like he had come to right a ship at the Wisconsin Supreme Court that was off the rails. And actually, I mean, it's important to point out, in the mid-2000s, the Wisconsin Supreme, that's the last time we've had a different kind of judicial philosophy on the Supreme Court. And the court was pretty brazen in its political decision-making. Justice Abrahamson was the intellectual leader of that court. You saw that over and over and over again. When Justice Gableman won in 2008, he flipped the court, the philosophy that governed the court. And we have had, by and large, for the last 10 years, a rule of law majority on the Wisconsin Supreme Court. And I want you to just take a moment and think about the history of the state of Wisconsin over the last 10 years. If you had a more political court rather than a rule of law majority on the court, we would have a very, very, very different state than we have right now. And the danger is going back to that for another decade to come. So, yeah.
What are some examples that you can give to reference what you just said? What
Sure.
issues?
Sure. I mean, it happened on all sorts of issues, criminal, civil issues. I mean, one example, there was a tort reform bill that was passed. I don't remember exactly what the year it was passed, and it was challenged. It was a cap on non-economic damages, which may not mean much to many of you, but it was called, the name of the case was Ferdin. And the court basically wrote a decision saying that no rational legislature could ever decide that a cap on damages in this in a medical malpractice lawsuit like this, no rational legislature could ever think that that would make any sense at all, which is absurd. Of course they could. Now, whether it's good policy or bad policy is a different question, but of course there's good, reasonable reasons why the legislature might not want to leave uncapped the amount of potential damages. Again, you can argue about the policy, but it's a different issue. And it was a pretty brazen opinion written by Justice Abrahamson. That was, again, very political. There's another case, a lead paint case dealing with, called Thomas v. Mallet, very famous case. The Supreme Court actually held a bunch of companies liable, even though there was no even allegation that they caused the injuries, which is the basics of the way liability works in court. It shocked. I mean, it made national news because it was so brazen. And there are lots of examples like that. There's examples in the criminal law area as well. So the court was it was a very political institution at that point in time, and we just absolutely cannot go back to that. So, well, listen, I'm happy to stay after and chat with some of you guys, but thank you guys all for your attention. Thank you for coming tonight. It's great to meet with you and meet you as well. This race is really important. I'd love to have your support on April 2nd, and we can win this race. And let's get going. Thank you very much.